So I'm just submitting a short written note about my submissions. Lordship may consider.
You want to?
Give it. I mean, it doesn't really matter. Mountain games, what 1 more 5 will make no difference. Yes.
Yes, Feroz, I'll now proceed rapidly. I wish to first take up the point on which yesterday we closed.
Yeah.
Which were two questions which were put to me by Justice Rastogi.
Yeah.
The first question was, as I understood it, with regard to facts and in the context of some of the reports that I had highlighted. And the question was, how do we ascertain facts in a situation or in a case such as this? This was one aspect. The second corollary was that assuming that a case on the facts is made out, how would that have any bearing with regard to the constitutional vires of the statute, which is being tested here before the court? Because regardless, do we not have to look at the statutory provisions alone for ascertaining as to whether there's some infirmity in the context of it not being implemented or being implemented in a manner which is deficient? Now, may I just supply my answers first and then just provide the judgments and the authorities in support? The first answer is that as far as ascertaining of facts in Article 32 and 226 petitions is concerned, and also particularly with regard to public interest litigations, the rule adopted by this court is that the facts have to be established generally on affidavit. That's one. A second corollary is that affidavit can extend to photographs and newspaper articles itself. And when I'm talking about newspaper articles, I don't mean the affidavit of the journalist or the author of the article. I'm talking about someone who's approaching the court in the public interest. So this will be the first measure or the first step in establishing facts. Once that is done, and if the court is satisfied about the facts, only if you're satisfied about the facts made out, that this requires an answer, then there is under our system the need for a counter affidavit or a reply affidavit contesting the situations. That again under 226 and 32 is done by way of affidavit. In the facts of the present case now, the situation is this. Right from 2017 when the Act came into force, we have placed on record reports authored by people who were authored by PETA generally, based on, as I indicated yesterday, ground investigations.
No counter affidavit is filed.
And there is no counter affidavit.
No notice given to us on these applications.
So on every application, the writ petition is filed in 2017. The writ petition is filed in 2017. There is obviously notice on the writ petition. There's no counter affidavit in the 2017 report.
Which petition are you talking about?
This is PETA. I'm only on one, which is, I'll give you the number, 1011 of 2020. 2017. So then there's a mistake you made on the cover.
The material you're laying on is produced in that?
Sorry?
Material you're laying on is produced in that?
Yes. So the answer is yes. And I'll just qualify that answer. The petition having been filed in 2017, and I've given you those details, so I'm going to just flag them. The petition having been filed in 2017, the 2017 report is part of the petition, right? However, for subsequent years, 80 applications have been filed, they have been brought on the record, and I mean, it's too late in the day for the state of Tamil Nadu, which has not filed a reply, to now say no notice was issued. Once the affidavits are filed and once the material is filed, if they want to contest it under our court and this system, we do not. We file an additional document, it's taken on the record, and if they wish to file a reply, they file a reply. If they choose not to file a reply, too bad. Now, this is the state of the record which we have.
Yes.
Now, please just, have you changed the number? Yes. Just now, give it to them as well. Now, we've put the authorities in this so that I don't have to refer to the books, etc. And your lordships will just pick this up. I've put 3 or 4 judgments in this, just for your convenience. And I'll go rapidly through this. The second point, while this is being marked and handed over, let me just indicate. The settled law in this court appears to be that what has to be seen is the effect of the law, the consequence of the law, not the facial phraseology used by the law. So therefore, to judge consequence and effect, facts have to be looked at, not the language of the statute alone. This appears to be the broad position, briefly to answer the question. Now we start with Mr. Sirvai's Constitutional Law of India, the 1991, which is the last edition. Please go directly to page 3 of the compilation. Para 9.355. Public interest litigation is litigation between, I'm reading the marginal note, opposing parties to determine their rights. Matter in the public interest litigation comes before the courts is normally by a petitioner presenting a petition supported by one or more affidavits. Counter affidavits are filed, and if necessary, affidavits in rejoinder and surrejoinder are filed. But having regard to the very large number of people who may be involved, the enforcement of strict rules of proof are relaxed, so that the power of the court to grant relief is not nullified in a practical sense. If lakhs of people are slum dwellers and pavement dwellers, proof in respect of every person to show the injury caused to him or her would prevent a court from effectively granting any relief. Therefore, slum dwellers and pavement dwellers were classified in broad categories. The circumstances under which the trial court granted the injunction, as stated in the judgment of the trial court, were taken into account. Photographs of the demolition or unauthorized structures occupied by the slum dwellers, published in newspapers, were admitted in evidence, it being left to the person opposing the petition to controvert that fact. In order to ascertain the factual position as regards the different categories of pavement dwellers and slum dwellers, the court appointed an officer to make a report. The report was admitted, etc. Relaxation of strict rules of evidence. It goes on and it talks about a counter this thing. So this is at least Sirvai's understanding way back in 1991 when public interest litigation relatively was in its infancy. Now I come to the second point. The second point is, and I'll just state the point. Your lordships had occasion to judge as to whether the law is to be examined on its face, or the language used of the statute, or the effect and consequence. Now, constitution benches, which I'm going to rapidly take you through, have held you have to look at the consequence and the effect and not the phraseology of the law. Now, let me give you an example. In the Bennett-Coleman case, for example, there was a tax on newsprint. That was considered, the tax on newsprint was not directly affecting 19(1)(a), etc. But the whole point was that, look, the newspaper size will shrink, advertisement will be impacted, and free speech indirectly will be impacted. I'm just explaining the context. Now, in the Article 21 context, this is the paragraph I read in the opening, so I'm just going to flag it here. Page 5 is Maneka Gandhi, 7 judges of this court. The relevant paragraph, which I had read earlier, so I won't read it this time, but it's in a 21 context, is at page 12. Page 12 of this compilation. It's the last 7 or 8 lines in para 19 and the first 6 or 7 lines in para 20. And the language which is used is direct and inevitable consequence of state action. So in Maneka Gandhi, the earlier paragraphs go to R.C. Cooper, they go to the Bennett-Coleman case, and then when this court speaks in Maneka Gandhi, it's about 10 lines from the top at 299. That's the print page 299, page 12. It is possible that in a given case, the pith and substance of state action may deal with a particular fundamental right, but its direct and inevitable effect may be another fundamental right. In that case, the state action would have to meet the challenge of the latter fundamental. I'm so sorry.
Sorry to interrupt you.
Yes.
There is a subtle distinction between
Yes.
the direct effect, the substantive effect of a law,
Yeah.
and the possibility that the law may not be followed on the ground,
Yeah.
and that it may be abused.
Right.
They are two different things.
I think so.
You're absolutely
So
correct.
let me just answer that. The direct impact of this law, let me tell you, is to continue cruelty insofar as bulls are concerned. That's my case. If you're not really persuaded by that case, then I think the consequences will be different.
It's a concept, because as to whether how it is being worked on the ground is a different thing that cannot be taken into consideration.
That has to be or ought to be. I can only say ought to be because you have material from 5 years on the record of this court, documented and supported by affidavit, which shows extreme cruelty and brutality in the conduct of Jallikattu only for certain incidents where we sent our people. So the cruelty is much greater because it extends. Our reports are for 5 days here, 1 week there. But the reports regarding deaths are taken for the entire, what I would describe as the season, the first 5 months of the calendar year, etc. So I'll come to that. But here the direct and inevitable consequence, therefore, to complete the sentence, is continuing cruelty. The continuation of a blood sport which this court has held is something which is so egregious and cruel that it cannot and ought not continue. That's the background. Now, on this point, I'm just giving you paragraphs. I'm not going to read it. Page 15 is the judgment in Hadige Sham Bhatt. It's another Constitution Bench judgment. The report is given 63, 3 SCR, page 809. You may just note the relevant paragraph, which is at page 17, paragraph 7. Page 17, paragraph 7, which says phraseology. I'll just read those 5 lines. Paragraph 7, after the quoted portion, though a ex facie law appears to treat all that fall within a class alike, this is an Article 14 case, if in effect it operates unevenly on one person or property situated similarly, it may be said that the law offends the equality clause. It will then be the duty of this court to scrutinize the effect of the law carefully and ascertain its real impact on persons or property similarly situated. Conversely, the law may treat persons who appear to be similarly situated differently, but on investigation, they may be found not to be similarly situated. To state it differently, it is not the phraseology of a statute that governs the situation, but the effect of the law that is decisive. The effect of the law is decisive because you just see the material, which I'm going to come to. Now, this passage, you may just note in the very same, because this is a 5-judge bench judgment, which your lordships have seen, has been endorsed by a 9-judge bench judgment, which I've placed in this, just 2 pages. Page 67, Chief Justice Thakur's judgment at 68, where this passage is quoted at page 68. So that is the entry tax case, etc. 9 learned judges of this court have endorsed this very paragraph that I read. To state it differently, it is not the phraseology of a statute that governs the situation, but the effect of the law that is decisive. So that's at page 68.
This
And
is the pit and substance in all the tax statute.
so,
Where
yes,
the coal says,
correct. So your lordship is right. So pit and substance was in the context of when Maneka Gandhi's analysis is under Article 21 and it draws in pit and substance. Why? Because as your lordship correctly put it to me, a levy, say in Bennett Coleman, was being defended under Article 265, etc. And they said that the pit and substance is under 265 or whatever. Don't challenge it under 191A. This court says that it is not going to go only by the facial.
the actual purpose of the law was tested.
Yes, the actual effect of the law.
The origin
The effect of the law.
US Supreme Court.
That I'll try and obtain the US Supreme Court case. I'm sorry, I don't.
The Chinese laundryman case.
There is.
Hopkins.
Yes.
I was
Yes.
trying to cite it.
Oh,
You
very good.
mentioned.
Very good, Mother. You're right. Lord,
That we versus not of that was possibly
the laundry case
The
may be.
famous evil eye and unequal hands. And therefore, if abuse is seen, this court, my lords, in a constitution bench, Justice H.R. Khanna has said that if that is established, then that is an exception. And therefore, you can look at the statute from that standpoint. That's what my learned friend is saying. If for 5 years after the statute is implemented, this is what you find, then you can't ignore it, saying that the statute.
So, my lords, I think Mr. Venugopal has put it very correctly. I believe it's extremely hazardous to ignore the facts established over 5 years, which are not contradicted and not controverted. Now, just nothing further. Page 23 is another Constitution bench judgment in Federation of Hotels versus Restaurant. And the relevant paragraph is paragraph 46 at page 47 of this compilation. Again, saying it is not phraseology which is determinative. What is determinative is the real effect of the provisions. Now, further on this compilation, please go. Now, yesterday, there was an issue which was, because a question was specifically put to me. I obviously hadn't read it, and I'm not going to tax this bench either by taking you through all the reports, so I'll go through one, the 2020 report. But the specific question put to me was like, how was this prepared? How was this prepared? Now, please go to page 69. Page 69 is an affidavit which we have filed today, only giving you as to how, because the report itself says how it was prepared. But this is in addition. So this is by a Deputy Director Advocacy Project of PETA. Please just go to paragraph 2. The petitioners have filed investigative reports in page 69, 17, 18, 19, 20, 22. The photographs forming part of these reports were taken by the ground investigators of the petitioner using DSLR camera, mobile phones, handycam and digicam. The photographs were clicked at various locations, including the arena, gallery, bull waiting area, and the collection yard. The said investigators have not been named in the report in order to protect their identity and safety since it is a sensitive issue. The ground investigators of the petitioners covered 5 Jallikattu events in 2017. We have given the dates and the details. Ground investigators covered 9 Jallikattu events in 2018 for around 10 days, 14 days between 14 January and 28 January, para 5. The ground investigators covered 7 events in 2019 between 15 January to 3rd February, para 6. The ground investigators of the petitioner covered 7 Jallikattu events in 2020 held between 15 January 2020 to 19 January 2020, and similarly 21 and 22. The contents are true, etc. The final part is, and I'll be closing with this, but not for the moment, I'm just inviting your attention. Page 73 is a definition, not definition, it's a description of what constitutes blood sports taken from the Encyclopedia of Animal Rights and Animal Welfare, the relevant portion being at page 75. Blood sports are defined. This would be covered by blood sports. And please see the last 3 lines on the right-hand column on page 75. Bullfighting is an example of animal baiting, in which an animal is goaded into aggression through pain, taunting, cornering, and so on. Then they go on, and the next para, animals subjected to blood sports routinely suffer terribly, both during the events and during the training of fights. Losing animals are often killed, etc. So this may be in a different context. Now I'm done with this particular compilation, but this is indeed a blood sport. Now please just take up the compilation I handed over yesterday.
Mr. Diwan,
Yes, I'm sure. Yes, please.
blood sport is a term that you're using.
Yes.
We find it very difficult to relate to the term that you're using.
Yeah, it is a blood sport. So just take up.
Why do you say?
It
Why do
is.
you say?
Yes, I'll tell your lordships why. So just have a look at the definition. We have a paper, in fact. Just have a look as to why this is nothing but a blood sport. Let me just tell you what it broadly involves. A blood sport is an event which used to be very common across the world. And it involves typically an animal. It involves a fight or a contest. And it involves, as has been found, a great degree of brutality and cruelty. That's one. Secondly, the scholastic material which we will place on record appears to indicate this, that there are movements across the world starting from the 18th century onwards, which diminished cruelty from a citizen's point of view. So there was an awareness among citizens themselves that, look, this sort of a thing ought not to continue. This sort of a thing should be restricted. This sort of a thing should be regulated. So that was one trend line. The second trend line was scientific in nature, because our understanding of the sentient nature of these beings also increased. So that was a second huge push. And this combined with a general awareness and legal reforms. So the reforms came in different ways. Some countries, there were statutes which were brought in. Some portions, in some parts of the world, culturally it changed. I'm sorry.
I don't think I'm getting an answer to the question I have posed. How you are describing this?
All right. So,
blood sport?
yes. So
Nobody is using any saber. Nobody is using anything.
it's not necessary.
Illicit blood.
Sorry.
So you are talking, I'm specifically talking about your understanding of the concept of blood sport.
Yes.
Why blood sport?
Yes.
If
So
you look at a bullfight, they eventually try
Just
to
a minute.
kill the bull.
yes. Sorry.
In another, this thing,
Right.
with a saber,
Yes.
they use a weapon.
Yes.
Here people are barehanded. Why are you describing?
Yes.
You may say that there are cruelty involved,
Just-
but you can't be describing it as a blood sport.
It falls. So
Don't give us this example of this definition at page 75.
No, I'm going to give you as to how blood sports are defined. And there's a scholarly paper. Have you got copies? Yes. We've given copies. Now, why blood sport? Now, let's just answer this question.
Yes, you must.
Yes. Let us just understand what is meant by blood sport and what's the scope of blood sport and whether this answers the description. Now, this is a paper which is part of a master's thesis, which I'm just handing over, which has a huge description. The author of the paper is Jack William Perryman. And now please just have a look as to the nature. I'm only answering the question. Please go to page 13, the nature of blood sports. So let me just see this, read this, and then your lordships will see it answers the description. Please see B, page 13, the nature of blood sports. Sports expressing an obsession with the death and torture of animals were popular throughout England. This is looking at England and America.
Correct.
The cruel amusements have been referred to by those attempting to prohibit them as blood sports. The term blood sport was used because the rules of the sports included the maiming, injury, killing, or bloodshed of innocent animals. Henry Salt, editor of one of the few books pertaining to blood sport, defined blood sport as those amusements which involve the death or torture of sentient beings.
You
further stated,
Mr.
sorry.
Diwan, you avoided 3 words while you were reading this sentence.
No.
Henry Salt, please read that again.
Henry Salt, editor of one of the few books pertaining to blood sport, Killing for Sport,
Yes,
1950.
killing for sport. Killing
Yes,
for
yes.
sport. This is
Define-
avoided reading.
Yes, defined blood sports as those amusements which involve the death or torture of sentient beings. He further stated that the worst and most demoralizing form of blood sports were those which make use of tame or captured animal and not one that is really wild and free. Blood has always been an important symbol and universally attributed with a special significance. In blood, an old hunting phrase, popular as early as the 17th century, means in full vigor or full of life. Raised in blood, another famous sporting line meant to make eager combat or bloodshed. Although no reliable source of information is available, the term blood sport itself seems to have become popular in England during the latter part of the 18th century as part of the propaganda of reformers, individuals who worked to eliminate cruelty from British sports. Later, around the 1820s, Humane Society leaders and humanitarians in England adopted the term. Blood sports soon became associated with cruel animal sports such as cockfighting. Bull and bear baiting. Please see, bull and bear baiting has nothing to do with the death of the animal. Dog fighting, gander pulling, rat baiting, snatching the rooster, the cock throwing in America by the 1830s. The cruel nature of British had been allured to by numerous travelers during the 18th century. The French, more than others, frequently commented on England's bloodthirsty people. So-and-so, a traveler through England in 1775, was shocked that all life was sacrificed in such abundance that blood flows by the brookful. Earlier in the same century, a visiting scholar so-and-so remarked in regard to the British that there's something in them that is great and which they seem to retain from the old Romans, that they have to this day a sort of gladiators, bull and bear baiting and dog fighting. Even as recently as 1875, Rapin, discussing British historian Max Lenner described the relationship between sport and blood. Sports do not for the popular culture of America what circuses did for the Roman culture at the height of the empire. They let the populace take part in this crucial ritual that binds them to another and to the culture. Every people, no matter how civilized, must have a chance to yell for blood. It can certainly be argued that blood sports were not only inherent to the British tradition. Still, blood sports were very popular amusements in England and America during the 17th, the 18th, and the early part of the 19th century. To some extent, this popularity must have reflected a culture in which cruelty, severe punishment, and an obsession for violence were prominent characteristics. Blood of death of an animal. That's the first point I want to make. Even in the human context, blood sports, which are like jousting, etc., may be gladiatorial, etc., but they fall short. They need not necessarily result in death. Here, of course, we have seen documented deaths of bulls, etc. Documented.
You see,
Sorry.
Mr. Diwan,
Yeah.
because death occurs, it doesn't mean that it will be a blood sport. All I'm trying to say, and I have not got an answer, at least to my satisfaction.
Yes.
I don't suggest
Yes.
that the people who are going to participate in climbing onto the bulls are going there in order to extract blood in that sporting event or whatever event that they wish. I don't think blood may be just an incidental thing, but it's not a blood sport. I don't think it's
Manoj, may I just say,
difficult for
first
me
and
to
foremost,
relate.
the expression blood sport is being used by me not because it is linked necessarily to the exposure of blood. A blood sport is an animal baiting exercise involving extreme cruelty. That's where I end my definition. That is what this scholar says.
You have said
and that's
so.
what the conclusion also says.
You have said so.
Yes.
But the bull owners are obviously not exposing their animals. But I don't think anybody is going there to participate in this Jallikattu sport to say that let us expose the animals to extreme cruelty. That it happens is another matter. I am taking exception to your use of the expression blood sport.
Anyway, I would
No,
describe.
that's right. You have given your answer.
Yes, I'm grateful. Now, I am not going to read it, but the summary and conclusions begin from page 198 of this. I'm not going to read it. It is of some utility, I believe, in the context, because it explains how there's been a gradual global shift away from animals in the arena, which inflict cruelty, whether we call it label it as a blood sport or something less than a blood sport. Now, I want to just answer one facet of this. And I'll deal with that on the basis of what we have already said. I'm answering a part of the question. Please go to the yesterday's compilation, which I've handed over, the compilation I gave yesterday, and please go directly to page 19, 19. Facts concluded by the earlier decision in Animal Welfare Board. Now, while that's being located, yeah, sorry.
This starts with the chart.
Yes, table A. So I'm going to table D, which is page 19. It's part of the answer. I'll just state the point while that's being located. The top page is compilation and rejoinder.
It's filed by Anne Matthew.
Yes, it's filed by Anne Matthew.
One question from the petition was said. Sort out the.
Now, sorry. May I take you to page 19, please?
Here.
Sorry, your lordships have page 19.
19, yeah.
19. This is of that. The heading is facts concluded by the earlier decision in the Animal Welfare Board of India, Nagaraj. Now, the third last bullet point, I'm just reading it.
Page 19 you are reading.
19, yes. It's on top, it's titled, it's stated to be table D. It's not really a table, it's a table of findings. And we've given you the specific paragraph numbers from the SEC report. So please go about third bullet point from the bottom. These are all culled out from the judgment itself. Jallikattu causes bulls severe mental and physical anguish. Now, this is a finding of fact. So apart from all my other arguments that it can't be overturned and except in review, etc., this is a finding of fact. Jallikattu by itself causes, by the nature and the anatomy, severe mental and physical anguish. Next bullet, Jallikattu is dangerous to humans. Next bullet point, pain and suffering are biological traits. Animals have pain receptors and a memory that allows it to remember what caused the pain. Pain felt by the animal is similar to the pain felt by man. Now I'm going to read only two more on page 20.
The way they argued that, mountaineering is also equally dangerous. People die every year. A lot of
Right. So I think
the government, this one.
Yeah.
The mountaineering, you have the mountaineering club.
Yeah.
It extends.
Yeah, Mr. Rodgi said driving a car also.
Driving a car.
Yeah, yeah.
So do we stop people from climbing mountains?
No. So let me answer that.
Adults.
No. So let me answer that. The answer. So here, it's a slightly different situation over here, as I at least understand it. This is a question of inflicting cruelty. It's a question of inflicting cruelty. And that ought to stop in terms of the animal. Now, let me answer a point which your lordship made, because you could have sports. So there is a concept which your lordships are aware of adventure sports or adventure activities.
Boxing.
Boxing also may be pugilism. Yes, it's possible that it is. So it's certainly something.
It's a bloody sport.
Yeah, it is. It can be. It can be. Now, therefore, you have a response. So, therefore, there's a global debate which is going on as to whether people should be wearing safety equipment. What is the type of safety equipment? People have. There are now long-term studies which show that even the most successful boxers suffer brain damage. So they suffer brain damage even though there may not be any apparent injury on it. So there's a lot of science which is developing. Maybe the law will evolve in a particular manner. But
Muhammad Ali, yes, Muhammad Ali already.
yeah,
Himself.
it's that's very, very possible. Very possible. So my answer to that is that if there is cruelty which is being, so this is, but I would not put, I don't believe mountain climbing, for example, since that's the example given to me, or driving a car amounts to cruel, or boxing voluntarily done amounts to cruelty. I don't think it amounts to cruelty. We are here on prevention of cruelty.
Cruelty to whom?
Cruelty to animals.
You spoke through the conduit of a human being.
Absolutely.
Invoking 21.
Absolutely.
So you are concerned about human lives being lost.
Both, yes.
That was what was being argued by the
Right. So, yeah.
It is voluntary. They agree. You can't
Both.
stop the adventure in the spirit in the man. That he wants to take the risk.
Yeah, so I'll just answer. Yeah.
Diving from,
Correct. So I don't think, yeah, you're right. So, Ballard, I think in aspects of driving a car, I believe there are elements of human agency involved. Animals, or our understanding of the situation, but lack that agency, and therefore they are compelled to, which is why we have the Prevention of Cruelty to Animals Act. And when you, because they don't have
We
agency.
are only talking about it from the standpoint of the human beings.
Yes, so there are two, your Lordship has put your finger on it.
You don't have to argue.
Yeah.
They can't give their consent.
Correct. So, Manoj, now I'm obliged for that observation. My point over here on page 20 is the last bullet point. Jallikattu and other forms of bull races, as the various reports indicate, cause considerable pain, stress and strain on the bulls. These factual findings completely establish the practice of Jallikattu is inherently cruel to bulls, apart from being extremely dangerous to human beings. These factual determinations, which have attained finality in relation to the state of Tamil Nadu, ought to be taken as conclusive. The submission is founded on the premise that legislation cannot open judicially determined facts and as such would be colorable. No material has been brought on the record in the form of scientific and technical reports that undermine these factual findings, and the Supreme Court itself ought to be respectful of the constitutional architecture whereby once a review is dismissed, facts cannot be reopened through the judicial process. Now, just going back to my table A, I'm not going to read it. Table A is a summary of all the details of all these reports. And I answered, or at least I endeavored to answer the question yesterday, which was the news reports are not random news reports. The news reports are from very reliable media journals. They have not been contradicted outside the court. I can understand because the number of deaths of human beings, of a child, of a policeman, of the spectator, of participants is huge, apart from the deaths of bulls, which are also documented. And we don't believe that reliable media houses would be making a story up in terms of all these deaths are concerned. So I agree, it is inherently, I think your Lordship's observation is quite right. This activity is inherently dangerous. It involves risks, etc. insofar as the human beings are concerned. Those human beings I accept are probably have an element of agency, the bull tamers. But spectators are dying. So someone may argue that don't go and watch it. Spectators even outside, your Lordships will find, if you find the time to go through this, spectators outside the bull run area, etc. Barricades are being, the bulls are jumping over barricades and goring people to death. And this is what we found in 4 and 5 days of investigation. So please consider that. That's table A. Now, so this is very detailed. It gives huge number of photographs and our sources, etc. Table A. I'll explain what we've done in table B. In table B, we have taken annexure 1 from the affidavit which they have filed regarding the process. Your Lordships had asked them to file an affidavit saying, please explain the procedure. What happens? So we have extracted the procedure on, we've reproduced actually in the left-hand column. We've reproduced it. And then we have given you the corresponding rules under the 2009 Act and the 2017 rules. And, sorry. Statement. And what you will find if you go through this is that it's really everything which was there earlier is really captured was already captured in 2009. And what they have said in paragraph 5, those participants who are intoxicated or suffer from deformities, we have made a comment that the state should not file affidavits which use expressions like this, suffer from deformities. This does not appear either in the 2009 Act or in the 2017 rules. And then we have given certain further details, etc., going right through towards the end. And for example, 8, when it says a second bull is let into the arena from the Vadivasal, after the previous bull has been let out, left the arena, it is ensured that any given point of time there is no more than one bull in the arena. Apart from the photographs, our comment is this does not appear in the 2009 Act or in the 2017 rule. That is our comment. And now please see 2018, my mistake, table C at page 16. Table C at page 16. So here we have given a comparison of the 2009 and 17 regimes. The role and duties of the collector remain more or less the same. The role and duties of the animal husbandry department remain the same. The organizer's duties remain the same. Penalty which was there earlier has now been removed. There is no penalty at all. Page 17. And you have a set of rules which we have. The animal welfare activists being present has been omitted. And at serial number 6 on page 18, we have pointed out that whereas they claim that there are rules now which govern, we have put overwhelming uncontroverted material on the record, which in our view establishes that there is no, the breach and cruelty being visited is such. Now, Manoj, I have just had a few minutes to reflect on this expression blood sport, because an issue was raised that we have used, and I have used the expression, because not in the pleadings, etc., the expression blood sport in a generic sense of a sport or an activity. I wouldn't even call it a sport. An activity or an event involving cruelty caused by baiting to a bull. Now, that baiting happens on different occasions in different manner. It may happen with a physical slap. It may happen with a jab. Merely prohibiting is not going to be enough when on the ground, this is in fact what is happening. So I'm very grateful. There are a few small other points. Sorry.
2 points we'd like to tell.
Yes, certainly.
The blood sport is very literal.
Sorry?
It is literal meaning to all these blood sports.
Yeah.
It does involve bleeding of the animal.
Yes.
Now, in 2000, when Nagaraja was actually decided,
Right.
you would have been correct in describing it as a blood sport because
Right.
animals were being, here and whatever, sharp material they were using.
Right.
It did involve actually blood loss.
Right.
Under the present dispensation, all
Yeah.
of that, at least in theory, on paper.
No, but we have put the photographs on record.
Now,
We-
two
showing
things
the blood.
we
Sorry?
wanted to clarify that about blood sport, what it means.
Yes.
I want to ask you 2 things.
Yes, certainly.
In the event that we are upholding these rules,
I'm sorry.
in the event,
Yeah.
we're just putting it to you as
Alternative. Yes.
alternative.
Yeah.
Like they have come forth saying that they're amenable to any kind of suggestion from the court.
Yeah.
What would you like to put in place, put in place, which would vastly improve, the condition of the animal? Number 1. Number 2, do you have to give any elucidation of the position relating to the rights vesting in animals in a jurisprudential way? What is it that you would like to tell us? Do you have anything to say?
Yes. So first, Manoj, I'll answer both aspects. The first point which I want to make is that I'm going to supply, because, for example, I have it immediately before me, page 74 of the 2020 report. That's a bull and a bleeding individual at page 83. But I don't want to take up your time. So I'm going to give you a statement of photographs depicting images taken from this event by our field investigators showing the spilling of blood human as well as bull. So that's going to be one part of the answer. So the blood sport element, the blood literal element in our respectful submission continues. The second, my lords, please excuse me, but I decline the invitation of providing a safeguard with regard to this thing, because we are fighting here as a matter of principle, and we will endeavor to persuade this bench or some future set of legislators or these things if the matter goes against us. But on this issue, I don't want to compromise. The third element was rights. That's a very important facet. Now, let me just indicate where we are. First, I have explained this in the opening, but so I'll just take two sentences. And Mr. Rothgi put it accurately, I felt. The foundation of animal rights, which have been used for the purposes of deciding Nagaraj, is a reflection of what the duties are as far as people are concerned, which are clearly, I mean, not imposed, but called for, required under our fundamental duties section, a chapter of the Constitution, as well as the Prevention of Cruelty Act, which puts it. So it's really a mirror image. So let's not use, so Nagaraj doesn't use, in my understanding, rights in a conventional, traditional sense as we would attach to human beings. One. Two, because I would commend the formulation by Justice Bose yesterday, that does it really make a difference whether we label this as rights or duties? Because at the end of the day, the object of the law is to prevent cruelty, and we would employ your lordships in whatever manner to ensure.
We want to know
Yes.
whether when Nagaraja says in paragraph 64, 65,
Yes.
66, 67,
Yes.
that they are at present rights under section 3 and 11.
Yes.
In favor
So,
of
my lords,
animals,
yeah.
to be elevated to constitutional right.
Yeah.
Are you saying that is the correct?
So, lords, let me,
law?
yes, so let me, now I'm speaking for myself, but then your lordship, because I answered it, addressed your lordships very narrowly. So I'll just first stick to my guns in, so to speak, as I did during the opening, and then expand it because your lordship says from a jurisprudential perspective. That other counsel did. Now, on the narrowest, if your lordship really, yes, please see those paragraphs, but please see the earlier paragraphs as to how the judge has articulated it. He has not said that this right is available under this section to this animal or the other. No, it's a very carefully and very well calibrated judgment, if I may say so. The reason I say that is that he draws on rights, or the animal rights which he pegs on. The animal rights Nagaraj is speaking of. Let me talk about that. The animal rights which Nagaraj is speaking of is, one, the reflection of the duty imposed on humans. Two, an assimilation of the 5 freedoms which are universally recognized, which I had mentioned in the opening: freedom from temperature, hunger, etc., thermal, etc. So that's another element into the rights of animal. That's the minimum requirement. And the third broad element which the learned judge finds is that, look, there is an improvement over time. There's an evolution of these recognition in terms of sentient beings, in terms of our understanding of biology, physiology, in terms of the bull. And therefore, we are moving in a direction where animals such as the bull, which is the only thing he was dealing with there, are at now a stage when we can, or the time has come when perhaps like the German constitution, some recognition ought to be given over there. But jurisprudentially, we're not speaking for myself. If the court is asking whether Nagaraj says that, look, a person A or B or C for an animal can come to court and petition, say, habeas corpus. So your lordships may be aware of the Happy case. Are you aware of the Happy case? No. All right. So Happy is an elephant in Brooklyn Zoo. And Happy went through an animal protection group and filed habeas corpus. The relief was quite limited. The relief said that, look, as far as animal rights, I am seeking habeas corpus, and the relief was that I don't want to be confined to Brooklyn Zoo, but please put me on a larger area, which, so not exactly a safari lodge, but a larger space, because animals require that space. Eventually, the Court of Appeals, as far as New York is concerned, turned it down. There was also a dissenting opinion. If your lordship likes, we will place it. But they said that we are not going to issue a writ of habeas corpus on the point that animal does not have standing in terms of approaching the court. So this is in 2022. This is a recent judgment. That's not how Nagaraj looks at it. Nagaraj doesn't say habeas corpus for this animal or the other, but it looks at rights. I like the formulation with respect, my lords, to what Justice Bose had put it. That's really the matrix in which your lordships may examine this case. I'm very grateful. Thank you.
Who else is there?
I'll take only 20 minutes. But I will not repeat a word.
Mr. Guru, but 20 minutes is not only.
No, but we're not in the context of 2 days, etc. I'll limit it to 15 minutes. Then.
do it at 15
minutes. 15 minutes. We have 1 hour. Whatever your lordships. Short, really short, my lord.
Don't tell us I take 20 minutes. We have to rise at 4 o'clock. This is what we are telling.
Exactly.
Right?
Key people will
We have to rise at 4 o'clock. Mr. Venugopal may take 50 minutes and then he takes away the time of the other.
My lord, that is how it should be. 20 minutes.
Therefore, you decide about yourself. Don't tell us. Don't tell us.
He's starting at
My
20.
learned friend starts, I just want to make one statement, Manoj, that these applications that my learned friend has relied upon have never been taken on record because the matter has never come up, Manoj, after he filed those applications. No,
Put it in
it's
written
never been
solutions.
taken on record.
But why didn't you file a counter to that?
Manoj, they've never been taken on record, Manoj.
No,
notice
I
on
don't know what the practice is.
The practice is exactly that. It comes on record, notice is issued. An application allowed, then only we file.
No, that's not correct, Manoj.
Manoj, that's a matter of record. I don't want to make an argument out of it. It's a matter of record. That's
I beg to differ, Manoj. Normally what happens is applications are filed, your lordships hear the matter, your lordships hear the other side, and then decide whether to take those documents into account or not. That's
All right, let us not.
Let us. But I won't trouble your lordship, not, and I have to be fair to my friends also, not.
In any case, those applications are related to either 7 events every year. And 396 events. They have nothing to say about it. No newspaper has reported about them.
All right.
But I also have to be fair, not to be unfair to your lordship, and not to be cruel to my friends in terms of taking their time.
All right.
I'll just give your lordship not. There are 2 issues that have been raised, and I'm only going to deal with 3 legal points and 1 factual issue. A lot has been said that on the existence of material. I'm not just for your lordship's convenience. I've compiled material from the petitions. Kindly just have a look. Page A is the nature of the sport and the similarity. Your lordship needed clarity at times. Not there's been an issue as to what is the nature of the sport. I've just put it down as to what is the nature of the sport.
Mr. Luthra, do you take it that any material you give now
Is from
would be in supersession of the earlier material?
But it is no. This is part of. This is everything.
We are naming it Siddharth Luthra rejoins us.
Yes, Lord. So
The reason is for us to identify it.
yes, of course, but I'm grateful. Now, not just see this for a moment. Page A, not because the issue has arisen about the nature of Kambala is.
Yes.
So what I've done is not made at page A chart as to what is there in Jallikattu and what does Kambala involve. And there are references to writ petitions. For example, please look at the description. Kambala on the right side, first column, description. Kambala involves agitating and whipping pairs of buffaloes which are tethered together to make them run as a slush track. Buffaloes may be tethered together using nose ropes, plows, rods, etc. and are maneuvered by the jockey for either using a plow, rope or holding on to. Now, holding on to and twisting the tail, see para 16 of the writ petition. So I've referred the writ petition lot. Now, please look below. The purpose of event is fine entertainment. See, animals involved is the same bovine family. Anatomy is important. They are barrel-shaped, cloven-footed animals unsuited to running. This is the finding of Nagaraj. So this is what Nagaraj said in Jallikattu. And this is the similar situation in Kambala and the bullock cart races on the right column. And on behavior, please see, herbivores, prey animals, resting behavior, adopt fight or flight response when threatened, frightened. That's Nagaraj. Page A, my lord. Page A. First page. And there is, on the right side, there is reference to a report, not page A, just page A of this. My lord, just look at the open page, this page. First page. First page, that's the gist. Not the landscape. I'm not even troubling your lordship with the landscape. Landscape, I'm just going to mention in a moment, Lord. Landscape will take exactly 30 seconds to deal with. Does your lordship have that behavior? Herbivores, prey animals, resting behavior, adopt fight or flight response when threatened, frightened. That's the Nagaraj noting in para 16 to 18 in the judgment. And buffaloes is part on the right. Buffaloes is part of the same board family, exhibit similar behavior. This is the AWBI report, which is part of the convenience compilation 1. On exploitation of fear, we have said both involve similar fear response. In one case, they're in Jallikattu, they're made to run into the arena. In the other case, they are made to run using verbal and physical force. Mr. Goel had very fairly stated that there is amount of whipping involved.
Yeah.
Not overly tail pulling was something which they were seeking to deny. Lord, one, Nagaraj notes it. And please note, I have placed on record, Lord, certain documents which are, one, it is pleaded. Please note what I've stated here. Tail pulling is not only rampant, convenience compilation 1 pages so-and-so, but is in fact part of the event itself in the Ada Haligi race, where the jockey balances himself on the plow and maneuvers the animal by pulling and twisting on the tail. This description as pleaded in para 16 of writ petition civil is not specifically denied by the state of Karnataka. This cruel practice is not prescribed in the notification issued by the state. That's the notification that is impugned. Then not below that, signs of distress, para 73 of Nagaraj. We have placed on record the reports brought on the right side. And similarly on the injuries, we placed on record reports. Now, Lord, that is so far as the gist is concerned of the sport. On the chart, the reason, please don't look into the chart right now. I'll just tell your lordship simply what it is. On all the issues of findings of actual cruelty, we have made a chart as to where it is stated along with the petitions, because an argument was raised. You've not pleaded this anywhere. You've not next material. Wherever it has happened, please just see illustratively on the first page of the horizontal chart. Baradi, Udupi, December 2014, page 39, volume so-and-so. So we've stated it completely, both AWBI reports, and it has gone on from 14 to 20 on the next page. Year on year, this has gone on. We just pointed out the relevant pages in the paper books.
Mr. Luthra, the first element on the chart is shouting.
Yes.
So just staying with the theme,
Yes, Lord. Yes, of course.
Blood curdling cries.
Yes, Lord. Yes.
Of a kung fu fighter.
Yes, Lord.
Just shouting.
Lord, I must tell you.
Yeah, judo chant.
Yes, Lord. Lord, that too can be menacing.
Correct. No, but they used to kill with the noise, with the voice thing. That's
yes, Lord. Lord, noise is important, Lord. It's a kind of inspiration to the
so
fight.
here this shouting, blood curdling can come
absolutely, in. Absolutely. Now please come to page 18.
Thank you.
And I don't want to trouble your lordship with that. But page 18, just have a look at one photograph. Mr. Go, there was an issue regarding how the sport is conducted. These are original AWBI reports, the Animal Welfare Board, which is also petitioned here, as to how it's been carried out. All the photographs are here, and colored photographs with the reference page numbers from the various writ petitions, nothing beyond. Illustratively, just look at page 18 and then page 20. Lord. Page 20 will be illustrative. It will give your lordship an indication as to what's happening. They're standing on the plow, pulling the tail. If my learned friends still want to say it's not cruel, or page 26, Lord, then I really don't think what else could be cruel. This is the reality of the sport. And page 46, where an animal is not willing to run, Lord, this is the treatment being meted out to the animals. So, Lord, that's so far as the documents are concerned. There is one article in this, which I will just come back to in a moment. That's at page 47. And that I'll just come back to in a moment when I complete the rest of the argument. Now, Lord, let me just tell your lordship what the issue is according to us. The first thing Yeah. The first point that I was seeking to make was in the context of Article 14. Our case is that the Amendment Acts seek to legitimize what is otherwise inherently cruel. And therefore, there can be no reasonable classification applicable. Now, if we want to test that argument on classification, look at the language of 28 and compare it with 28A. 28, and I'm not going to refer back to it because I don't want to take time. 28 was an exception created. 28A says the entire act is accepted. Nothing in the act will apply. Now, if nothing in act applies means 11 doesn't apply, which means the entire regime of the act is taken out and there's no penalization left. That's the first point. The second point that I want to make is, can it be a situation that whipping an animal under 11 or treating an animal under 11 cruelly is punishable under 11, but not in a sport? So 28A will take all these so-called sports out of it. That can't be rational. That cannot be the basis. And it's hit by 14. Similarly, what is Kambala?
Supposing the animal is actually used for transporting the drought.
Yes.
I mean, do they get whipped from time to time? If they don't, because
Lord,
they slow down a little bit.
In fact, Lord, I must tell your Lordship, there are specific regime for drought animals and how they have to be treated, how much load, how they have to be treated, no cruelty, all of that is provided in the legislation. I must also point out, Lord, look at the irrationality of it. What is Kambala? It's defined to say, Kambala is a racing sport on a given day. So it says on a given day between November and March, these are the annual races. Just a minute. Now that is how it's essentially defined. Now, if that be the case, then in Kambala, cruelty is exempted. If you're racing otherwise, it's an offense. That can't be a rational basis of defining what it is. And therefore, I would submit, Lord, there's a problem there. The second part is, there is a vagueness in the term. There is no clarity in section 2AA, which is the defining section, and 2DD, as to how it is to be read. 2AA and 2DD. They don't specify the nature of the sport, therefore it's hit by vagueness. Now the question is, Lord, you're relying on culture. If you're relying on culture, and I would place just the citations of two decisions for your logical consideration, you must give or have given proof of culture. There is no proof barring anecdotal material. And for that, may I just point out, 1963, Supplementary 1 SCR, page 112, para 5, it's Gujarat University versus Principal St. Xavier's College. Secondly, Lord, in the context of Article 29, Lord, there's an opinion of Justice H.R. Khanna, concurring opinion in Ahmedabad St. Xavier's College, Lord, 1974, 1 SCC 717 at para 73. All of these are part of our compilation. I'll give the courtmaster the page numbers of the compilation.
But if legislature says that this is culture.
Yes, sir. Yes. Not the only
that event is a historical research necessary.
Not if I may say so. That's our whole point. That's what the judgment say, that you have to give proof of culture to bring it within the cultural exemption or to realize or to exercise Article 29. It can't just be stated as culture. Not two answers straight away. One, merely because the legislature says it's culture does not elevate it to the ground of culture. There has to be some basis of it. And secondly, Lord, the other issue is, are we not also to see whether every cultural practice is to be held acceptable in this day and age? Because it is not necessarily assuming that it's a cultural practice, assuming there is evidence for it, which I believe there is none. It cannot be a situation where we can assume that it should be acceptable in today. And not just, and I may point out, Lord, it's a very interesting thing your Lordship put to me. In Kambala, it says, and in fact, Lord, I must point out, in Kambala, the words used are, Kambala means the traditional sports event involving male buffalo race normally held as a part of tradition and culture as may be notified by the state government. So you give complete power to the state government to determine what it is not. That's with respect, may not be the interpretation, not which will survive. And similarly, not is the position in Maharashtra. Not. They just say bullock cart race, leave it totally vague. My lord may also recall para 42 of Nagaraj. Not para 42 of Nagaraj, para 52 of Nagaraj has also picked up, which your lordship had highlighted, the contrast between the Maharashtra earlier opinion and the Maharashtra view now, which is a somersault. So I'll leave it at that. Now, not two more things. There is, with respect, no nexus with the preservation of native breeds. They've just talked about it. Bulls are showcased, they're sold. That preservation is there through that process. Thirdly, an argument was made on food. Now, food is part of food, not in that exception on food. So the distinction is culture and food are two distinct things. Food may be impacted by culture, but they're not the same thing. But one more judgment on this pre-constitutional practices. I'm just giving the citation. 2002, 8 SCC 106, paras 15 to 18, N. Adityan. This was argued, no response to this. N. Adityan versus Travancore Devasom Board. It's volume 1, page 96. Now, Lord, two more things. And I'll just, I find I have limited time, Lord. I'll try and wind it up because my other friends have to also go. Lord, on arbitrariness, I just want to add an activity for entertainment or amusement cannot be within the exception of doctrine of necessity, which is the golden thread. It is the ethos behind the PCA Act. One, protection of animals, and the only exception is the doctrine of necessity. The doctrine of necessity is rooted in reasonableness, in proportionality, because the idea is for the health of the animals, for the health of society, for the well-being of society, and science and food are the two exceptions really. Our submission is you cannot therefore have exemptions for these sports without determining this principle in the context of the PCA and the ethos behind the PCA. We have pleaded this at various places, even in the PTR report, but I want your lordship to consider one more thing, Lord. The state's argument has been, and the argument that was sought to be made at various places was that there is a regime change and therefore there is no cruelty. They placed an affidavit, which is of 4th of December 2022, Annexure 2. Please just see Annexure 2 and see the nature of the photographs as also their argument. They admit now that 25 people are led into the pen at one time, into the ring, and it is no longer one participant and one animal. Therefore, not, I would say this itself is apparent that there's a flight and fight response, and therefore the Nagaraj factual findings have not changed, and therefore there is no change. But just one more submission here. We talk of constitutional morality. My submission is, and I'm relying on Raftesh Johar, the acts, rules, and the notification of Maharashtra do not square with constitutional morality in Article 51, GNA and GNH, 48 and 48A, Lord, and therefore it must. The other two submissions, Lord, I've given your lordship is a one-page chart on the similarities in the sports. There are findings in Nagaraj, both on bullock carts and Jallikattu. Those paras are there, your lordship has seen it. I don't want to trouble lordship further with that. And there is an argument that was made that animals have been used like this for many years. So why stop now? The fact is not. Nagaraj said they are unfit for these kind of events. Today, that finding of fact has not been changed, and merely changing the so-called nature of the sport doesn't change it. Most important on this plot, while Maharashtra and Tamil Nadu bring out rules, Karnataka has not brought out any rules, as I pointed out, only a notification.
There are no rules made.
Only
Only a notification, bro.
Notification.
Notification.
Under 3.
That's right.
Only a notification. Now, not the last part. The lordship had put a query to me, to others also, not on the issue of personhood. So there are three answers there brought on personhood. The first is human beings have a right to environment an environment where animals are not treated cruelly. Ahimsa was one of the founding bases of this nation, and therefore the submission is this: we cannot do away with a principle of a non-violent environment. Secondly, animals may not be entitled to personhood in the extent human beings may be, but they have a limited right: the right to live without unnecessary cruelty and a right to be in dignity. I'm not on this.
What happens when they are, killed for the purpose of eating?
Not that.
What happens to the right to live?
Not that.
Not an absolute right.
It's not an absolute right. I said limited rights, Lord. I said limited rights.
Yeah.
I began with that. Now, Lord, the issue is, what is the limited right in this regard? And I'll come straight to that. Now, Lord, there is a duty in human beings, Article 51 TNH, 48 and 48A. Therefore, the question is there a corresponding right in animals? Not that they may necessarily be able to actively exercise it, but is there a right? In this regard, kindly just consider three things, Lord. There is an article at page 47 of what I placed to your Lordship. Your Lordship has seen that, Lord. Please see that article. And that deals with also the issue which my learned friend, it deals with Nagaraj. It relies on Nagaraj. Lord, page 47. It will refer to Nagaraj, Lord, at page number 534 bottom. Last two lines in that last para on that page, 534 overly 535,
Yes.
refers to Nagaraj.
Yes.
And again, please see 537 on the formal structure of rights, Lord, and how it deals with the federal principle.
Okay.
And not just one thing,
I think you have to.
Lord, just one more minute. One more minute and I'll be done.
More than 20 minutes here.
Lord, all right, Lord. I will leave it, Lord. Just one more thing. Kindly just see the categorization in state of Karnataka versus Union of India, 1977, 4 SCC, Lord. Last thing, Lord. On the presidential assent, Lord, I just want to say one sentence. Para 77 of Kaiser Hind makes it clear that your lordships have the power to consider the files. The state can't regulate. If there is an issue of presidential assent, it isn't, your lordship power is not fettered, Lord. The kind of response that was coming that the files were not to be given, Lord, it was not fair and it's not tenable in law. That's all. I'm deeply obliged.
Thank you. Thank you. Yes.
Grateful.
Lord, first a few small points. And I won't repeat. On culture belongs. Nagaraja says, as far as Tamil Nadu is concerned, the way Jallikattu is being practiced today was never practiced earlier. That is also a finding of fact. They have not said anything to the contrary. That's one. Maharashtra lordships have noted there was a ban. I'm not getting into that. Lord, there, of course, they had the castrated bull. And therefore, the Bombay High Court said, look. Thirdly, even if you have culture, and I'm separating culture from religion, your Lordship, my Lord Justice Joseph said, they're part of the same thing. With respect, my Lord, 25 and 29, there are different spheres. And as far as religion, see the argument of Mr. Navde in the review. Only religion was pleaded in 25. So the argument is not correct on that. Now, secondly, my Lord, on presidential assent, your Lordship took the documents. I don't know what your Lordships have come to in terms of having looked at it. What is your Lordship's assessment? I can't ask my Lordship to give them with the files. But please appreciate my point.
Yeah.
This is a peculiar case on two counts. One is that the rules are being framed which are actually the rub of the matter. Because your Lordships are also thinking, and this is what I perceive, and I'm doing in the best interest of the bar and the bench, to see how a conversation we should have as no, your Lordships are also thinking, is the regime being changed and therefore we are looking at the rules. Now, in this case, rules are the nub of the matter. Now, in my respectful submission, under 254, when assent is being sought, in this case, there were no rules. They just said, we are immunizing you from 11. Please appreciate, immunizing you from the rigors of section 11, and that will be done by rules. If you don't have the rules in front of you as the president, how will you give your assent? Because both in Kesara Hind and Gram Panchayat, your Lordships have said that information should be such that the Honorable President can make an informed decision. So, in my respectful submission, because the rules were not also placed, the information is incoherent. is not full. Therefore, in my view, the president could not have given assent at all. This is an additional thing. And what, I don't know if your lordships have been cited, Gram Panchayat, but just take the citation, Vinod. That also follows Kesar in, but more elaborately, 1985 3 SEC 661 para 48. 1985 3 SEC 661 para 48. Your lordships are aware, the proposition is the same. Now, my Lord Justice Rastogi asked the question, what is the parameters of a challenge? Not only after Cooper, Menaka Gandhi, your lordships have held direct and inevitable, but not interestingly, Brown versus Board of Education, the same thing. But I'll just give your lordship the citation. Just give the copy. I'm not reading it. 347 US. 347 US 483 at page 492. The actual impact. Now, this is very important because that case was similar like yours. This one. Because legislation had come into force. Your lordship know this was the first case in the US where the decision was rendered and they had to actually have a continuous mandamus. So the question was whether you can actually look at the actual events and they
separate.
Yes, and that is very important. I thought that would actually assist your lordship in deciding
We'll
this.
go through that.
Yes, I'm not reading it out. Now, my last point, which is my key point on dignity. Let me rephrase the point, Milord. Milord, in the courtroom as we are now, we are oblivious to what is happening. In the world, in the continuum, this is very important because there is a crisis today. And the crisis is of, which is now noted by everybody, of climate change. Where children are protesting, what will happen to our future? In that context, the continuum of human beings with nature, with plants and animals is of seminal importance. And Nagaraja situates that in that context. Please appreciate. My learned from Mr. Rodki mentioned certain things. I would say that is from a perspective, with full respect to him, in the fixed time zone. Because you are looking at human beings, plants and animals in a particular way. And in fact, the disaster has visited Earth, Mother Earth, because we have not actually accorded due deference to elements of nature, which are plants and animals. This is my, I'll give a written note on this. And therefore, for the ecosystem to survive, we have to actually embark. And that's what Nagaraja tried to do, Milord. And Milord very carefully calibrated and did not overstep, if I may say so. Unlike my learned friend Mr. Rodki, said, no, this is not. I would say it was calibrated. The learned judge was very careful, not embarking on something adventurous, but seeing the problems that are actually confronting humanity as a whole, actually posited these things, such that if you do not give due deference to animals by way of dignity, then we'll be losing out on the race to save this planet. It's in that context it becomes seminal.
Okay.
And number second point, the starting point of this is to see sentient beings. Your lordship been told that. Then, my lord, this is the framework. This is the framework at the present. Actual doctrine of necessity, food, etc., exceptions, experiments, and not causing unnecessary pain. So whatever queries that have actually fallen from my lords, why this horse, we are actually riding a horse, there's pain, that are all covered in that framework. Because we still see sentient beings, animals, as serving us. That equation is changing over a period of time. And we should situate ourselves in that continuum of change. If we see the lordships can give a decision. Jallikattu should be held, the rules should be changed, but that will not be doing justice to this issue, which is of seminal importance. So, your lordships must situate your judgment in that continuum. Now, my lord, I want to only advert to two articles which are in the compilation, Lord. One, I'm tendering because that is the latest. There is no point in having a 1999 article. Things have changed from then. One is in your lordship's compilation, Mr. Luthra's compilation.
We have noted that.
Yeah, that. There's another one. I want to give this, this is a very important, this is the latest. And though there are issues which are being raised there, and the learned author is questioning herself. Am I right? And that should be the spirit of inquiry. I may be wrong, but I'll inquire.
Yes. Give us the name of that.
But I've given a copy of that. I just want to advert to certain paragraphs in the 4 minutes I've left.
Yeah. If you can just give us the paragraphs and just.
I'm just,
No,
just
it's
one
time, that's
couple.
a good-
No, I'm within my time. I'm not going to take more than 15 minutes. This is called Eva Burnett.
Correct, correct.
And it's on the specific issue of dignity.
Yeah.
Now, what I want to say in the beginning, my lord, just see.
Give us a page, we'll go through it.
Yeah, I'm not going to. Lord, I'm not going
We'll
to.
take it, we'll go through each and every
Yes,
word of it.
Lord, I'll give you. Only one thing I want to point out. It actually looks at dignity in the context of animals, and actually evolves those principles.
We'll go through it.
Yeah, very well, my lord. I'll actually, if your lordship will allow me to give a written note, I'll point out those passages. But please, my lord, your lordship may hold that Jallikattu is permissible if we actually go and say there's no dignity to animals, which is a separate issue philosophically and in legal jurisprudence, we'll be doing a huge amount of damage. And my lord, only last point. The Indian Supreme Court has been known to be an avant-garde court all over the world. It throws light to the rest of the world in its jurisprudence. I have traveled extensively and visited number of courts, and they always ask, how is it that Supreme Court does this in India? Now, I don't want your lordships. Whatever your lordships hold, that is your lordship's prerogative. I always tell to the students, you have 100% control on your argument, in your preparation and drafting. Maybe 30, 20, 40, 50 on argument, but 0 on judgment. Lord, all I would say is please preserve the essence of Narga.
Thank you.
Much obliged.
Thank you. Thank you.
Let's, I just want to make some submissions very briefly on the factual matrix first. Let's, I would remind my lords that women and slaves also were considered chattel and property once upon a time. By the same token, as we get to know more and more about the physiology, as well as and I believe my lord, in fact, has some background in these matters, as we get to know more and more about the physiology of animals, as well as how their brains function, we are also attaining a much greater understanding of how they are to be treated, that they are sentient beings. There may be degrees of intelligence. For example, our own Ministry of Environment and Forests has issued a circular banning dolphinariums because they say they are intelligent species. Now, I am respectfully submitting that the philosophical basis for animal rights is that animals that are the subject of a life, that are sentient, are entitled to have rights. That's where the international view in terms of forging a treaty that would protect animals is going. So we are not yet there, and I'm not saying, my lords, that there is an international treaty today that binds us down. But the 5 freedoms, my lords, come from international law. Now, having said that, I want to make the next point. My learned friend, Mr. Shyam Devan, used the word blood sport. Now, my lord is right to question whether one can call this a blood sport in the traditional understanding of the term. But I want to put it in a slightly different context, which is in ancient Rome, my lords may recall, they had the Circus Maximus, in which people used to come, Romans used to come and watch animals fighting each other, animals versus people, and gladiator versus gladiator. And these were blood spots where the crowd, and this is where I'm saying there is some similarity to what is going on today, where the crowds enjoyed the fact that they were fighting each other and that blood could be spilt. I'm only asking my lords, and I'm not going to say anything more on this, I'm only asking my lords to reflect on whether this sort of primitive urge, atavistic primitive urge in people, is not the reason why there are spectators who go to watch a bull with very sharp horns being grappled with by people. There is always a chance that the bull's horns will gore the individual concerned in the course of it trying to free itself. That, my lords, in my respectful submission, is the core, or is what is behind the notion of a blood spot. We are ultimately, my lords, human beings who hark back to a few millennia ago, maybe tens of thousands of years ago, to people who used to be hunter-gatherers. Even today, one will see chimpanzees apparently hunting other chimpanzees, though we think of them as very lovable-looking animals, ripping them apart, even if they are chimpanzees, and eating them. So I'm only saying that we have evolved well beyond what was considered permissible in ancient Rome. And the question is whether this practice today does not take us back 2000 years in terms of what it really seeks to promote.
Mr. Venugopal, just one comment.
Yes.
From your Maximus and Gladiators, you see, the only people or only element in this Jallikattu sport with sharp weapons are the bulls.
That's correct.
So if the spectators are coming to watch the bulls goring people to death is one way, but perhaps the projection is that it is the bulls who are being tortured and treated with cruelty.
Both sides.
But the spectators are not coming with any sharp weapon. Only the bulls are having sharp
Your
weapons.
lordships are right.
So that's all.
Your lordship is absolutely right. I am saying the spectators are there because of the excitement. In the Tamil Nadu affidavit, which I finally got, I must confess, and went through, they talk about the heroism inherent in the struggle between man and animal. What is this heroism? Actually, it is the individual who is willing to go into the arena with the bull, wrestle with it. They call it embracing. In the earlier act, it was called taming. Embracing it and potentially getting gored. I'm only saying, therefore, that element of the spectator's primitive urge being satisfied is part of blood sports, is all that I'm saying. The fact that spectators, incidentally, are also getting gored is an Article 21 aspect where I say there is no culture here, there is no necessity here. This is purely for human enjoyment. And that is why a vocal, vociferous minority has made this a huge political issue, which is why the Tamil Nadu legislature was forced to go into special session, pass it. The center gives presidential assent because they don't want to alienate a substantial section. They believe that it could potentially lead to losing a huge fringe minority's votes. Your lordships would appreciate there's a large silent majority always, whether it is farmers who burn stubble who are a single.
There we are having problem, Mr. Venugopal. See, we are not deciding here what is right and what is wrong.
No, I bow down.
What
I bow
we are
down.
deciding here is whether it's legally permissible or not.
Yes. Your lordships are right. Let me come back.
There are social norms, there are legislatures.
Yes.
We are not the only one who lay down the norms. In fact,
Your
we
lordship-
lay down the norms.
Lordships are right.
The minimal.
I want to submit one essential fact which your lordship should know, and I believe your lordships would not ignore. In this entire thing, my lords, in this entire process, there is no reason, and this was placed before your lords, I believe, in previous versions of the Jallikattu case. There is no reason why a bull will leave the Vadivasal, which is where they are gathered. There is no reason why a bull will leave that place and run into the arena, except that they are in fear of torture inflicted. Everybody says that there is no torture today, there are vets, there is this, there is that. But the fact of the matter is, people want to see the bull run. And no vet, no government servant, no policeman is going to prevent the bull from running. In order for the bull to run, you have to torture the bull. And when I say torture the bull, I am saying the photographs that have been placed on record show that they poke them and prod them with sharp objects. In the old days, they used to pour alcohol down their throats. Today, even the photographs show that there are men biting the tails. They break the tail. This is the only way to make a bull run. If your lordships have seen bulls wandering on the streets of Delhi, which one can all the time, huge bulls, smaller bulls, etc., no bull runs. A bull runs only when it is threatened and is in fear. So the submission I'm making is that part of the cruelty your lordships may kindly keep in mind. They will not leave the Vadivasal unless
We understood.
they're treated cruelly. The second thing I wanted to tell my lords factually is I want to hand over a small diagram, my lords, which shows based on the rules 5 and 6. I had requested your lordships repeatedly to watch a video. Your lordships have not done that yet. Even now, if your lordships are willing to watch one in the privacy of your chambers or together in chambers, that would be good. Because I am telling my lords what they are saying is not correct. It is not a question of 9 people or 10 people. There are at least 25 people which has been admitted. Yes. Do you have more of these? Please give the 2 remaining on that side. There are none. I'll hand over my copy.
Compilation filed in a constitution bench are hundreds of material directly given which cannot be replicated.
No.
It's not done by like any day. Often directed to give a compilation.
My learned friend may just note that this is a depiction of the rule as it stands, where your lordships had a question. Please see, my lords, it says 50 square meters in Rule 5. Therefore, 15 meters is the length the bull has to run. There is just 3.3 meters, which is roughly 10 feet, I would say. 1 meter being 3.3 feet. So this is roughly 10 feet. And there are 25 people and there is a bull. And the size is drawn roughly according to scale. So the point I'm making is the bull is still in fear when it enters this arena and it has to run. And that is after having been prodded to the point where it is excited. Just like your lordships may recall the bull run in Pamplona, etc., Pamplona in Spain, etc., where they run through the streets and people get gored, and in Spain it's considered a cultural practice and therefore they allow it to happen. I'm only saying in our country, this is a different situation. Now, my lords, and the point, I'm not going to repeat the point that my learned friends have made, there can't be any necessity, my lords, to this practice, which is the basis on which and this is a point I wanted to make to my lords. I have actually gone through, I'm not going to trouble my lords with it, I have gone through the preparatory legislative materials which led to the passing of this act. I believe it was Maharani Amrit Kaur. Oh, who was the lady who? Sorry, it was Rukmini Devi Arundale who piloted the bill, and it was based on compassion for animals and for all life that led to the passing of the act. The parts of the act which carve out exceptions were intended to only reflect the prevailing practices in human society out of necessity. You can't tell poor farmers in the 1950s that they can't use a nose rope, that they can't be asked to plow the field, that they can't be used as draft animals. We had no mechanization at that time. Yeah. So this is a point about how the act came into force, contrary to response on legislative competence. On this, I wanted to make one important submission. My learned friends have talked of this amending act as though it is an act passed by a competent legislature on a tabula rasa or blank slate. That is not the position here. The fundamental point which they have failed to answer is that it is in the background of an existing statute passed by Parliament, which has been interpreted, applied, and certain principles laid down in Nagaraj, which is a binding judgment of this court.
I'll ask you only one question there.
Yes.
Section 11(3)(a) to E
Yes.
is traceable to his entry.
My lords, that I am respectfully submitting is by Parliament in a particular context. The submission I'm making is this: by Parliament in a particular context where they have taken account of current societal needs, I am submitting that when the state of Tamil Nadu is passing this act, there's already a framework of an act in place, and on top of that, the court has rendered findings of fact on 3 essential aspects.
You're not answering my question.
Yes, my lords.
See, legislative competence cannot be deflected, or you can't dodge the issue, because either the sovereign legislature has power or it does not have power. So that is why we asked you that question. 11(3)(a) to E,
yes,
made by Parliament, is traceable to entry 17.
Correct.
Entry 17.
No difficulty.
You only wanted to know.
Yes.
That's enough.
That is, they've carved it out. No difficulty. Now, all that I'm submitting, my lords, is thereafter, there is a judgment of this court upheld in review. So 4 learned judges of this court, my lords, have applied their minds and in review upheld it. In the judgment in Nagaraj, there are 3 findings which I wanted to mention to my lords, which are factual findings, which are very important. I hope, my lords, I'm clear. One is para 16 to 18, or fight or flight response of bulls. That is essentially one aspect of why it is cruel. Second aspect is they're not anatomically designed for being performing animals, which is 43-44. Then, my lords, 53 is the crucial paragraph where there is a finding that this is not part of Tamil culture after they had full freedom to place whatever material they wanted. It's a finding of fact.
In the form it was practiced.
No, my lords. With respect, what I'm trying to tell my lords is, and this is where, my lords, I may endeavor to just place before my lords my perspective, only in an endeavor to persuade my lords. If Nagaraj had not held that because of fight or flight or the anatomy of the bull, that it is cruelty factually to make it perform, then I would have said in the form is all right. But there are these 2 findings of fact based on a review of the scientific literature is what I'm told. Now, if that be true, then there is inherent or intrinsic cruelty.
We follow.
Yes. So, and it can't be culture because there's a finding of fact as to this practice of bull taming not being part of culture. By simply changing the name and saying now it is bull embracing, rather than the learned judge in the judgment says, this is not a case where they're embracing the bull. And therefore, they say, I've cured the defect by saying that you will only embrace the bull. But when you have 5 years of data, which clearly show newspaper reports, which have never been refuted in the public domain by the press agencies of the government of Tamil Nadu or anybody else, 5 years worth of data on the implementation of the act. What becomes clear, my lords, is this is a case which is akin, I'm not saying it's identical, to the famous phrase used in Iqbo versus Hopkins, 1986 US Supreme Court, that this is a case of an evil eye, a law being implemented with an evil eye and an unequal hand. Now, I must admit that His Lordship Justice Matthew, in the judgment which I am going to just place, I'll just give my lords my lords, if your lordships wants to see paragraph 11 of the SEC version of Iqbo, it says specifically that if a law on its face is okay, but the way in which it is implemented is that white people will get laundry permits to run laundries in wooden houses, 90% of San Francisco being wooden houses, while Chinese, who ran the vast majority, 90% of the laundries, would not get it. So this is the position. Now, I want to add that there is a recent judgment of His Lordship Justice Chandrachud in a case called Nitisha. I'll give your lordship, just give me my pen. I'll just give my lords a citation. It's AIR, 1 minute, my lords. AIR 2021 Supreme Court 1797. And the paragraph, which I'll just read out 3 lines from, we must clarify here that the use of the term indirect discrimination is not to refer to discrimination which is remote, but is instead as real as any other form of discrimination. Indirect discrimination is caused by facially neutral criteria by not taking into consideration the underlying effects of a provision, practice, or a criterion. So the law has moved a bit further, my lords, from Justice Matthew's dissent to a position now where they're looking at effects. I just wanted to complete my submissions by pointing out that essentially what I'm saying on legislative competence is, after the findings of fact in Nagaraj, it is no longer permissible for state of Tamil Nadu to pass a law under 254, which is reserved for consideration of the president, by saying that it is now prevention of cruelty. And the 2 judgments which I relied upon, G.S. Chawla's judgment.
You have given that.
No, they have not answered it, is what I'm trying
We'll
to
have
say.
to go through that. We'll have
Yes,
to take
G.S.
up-
Chawla's judgment is on that radio apparatus which was in the list 1. The second judgment, my lords,
97.
97 Supreme Court, is Indian Aluminium. My learned friend sought to distinguish it by saying that Indian Aluminium was a case that relied on synthetics and chemicals. Synthetics and chemicals has been referred to a larger bench, therefore it is not a good law anymore. I want to make only 2 points. First is, it nowhere mentions synthetics and chemicals. Second, it is a case of colorable legislation where they said that you cannot say that you are taxing land as a unit if you are correlating it with the void and use of forest land. And that was also an attempt by to overcome a judgment of the Supreme Court. So my respectful submission is, this cannot be traced to entry 17 list 3. It cannot be traced to entry 15 of list 2, which is preservation of native breeds. There, the key point I relied upon was livestock, is about farm
What
animals.
about entertainment?
Well, this, my respectful submission, when one looks at,
Because you say this is entertainment.
yes,
So entertainment is an entry in the state list.
I bow down. All that I'm trying to tell, my lords, is that if one looks at the whole of it, it is about animals. There's no such entry which deals with entertainment by animals in list 2, number 1. And number 2, if it is a law passed under entry, I believe 33 of list 2, which is sports and entertainment, etc., then first of all, the objects and reasons do not talk of that. They did not trace it there. They have not taken a position on affidavit that it is entertainment, number 1.
You go to a circus, is it entertainment?
Maybe.
Who entertains us? Animals.
No, that has been banned now.
Also.
That's been banned.
Animals also.
5 animals have been banned, my lords. Your lordships have upheld that. So the submission which I'm making, my lords, is this, that the repugnancy argument and the president's assent no longer holds good. Your lordships are aware of the judgments, Hext Pharma, etc., which say that you can take presidential assent and cure repugnancy only if it is a subject in list 3. So the state can pass a law on list 3 and then take the assent. Lastly, my lords, I want to distinguish myself, my argument under Article 21, slightly from Mr. Grover. The only submission I'm making is, if your lordship sees para 75 Nagaraj and read the second sentence carefully, it is relying upon the right to a safe, wholesome environment. And it is the animals which are part of my environment, which I don't want to see treated cruelly, my lords. Which I don't want to see treated cruelly. The dignity aspect comes in, my lords, because I don't want to see, even in my personal capacity, walking along a street, I don't want to see somebody whirling a dog around by the tail and then dashing its brains out, as appeared in newspaper articles. So this is part of the submission on dignity.
Thank you.
And
Giri, give me 10 minutes. Yes, we have to raise it.
Yes.
More sharp. Yes.
I put the rest of my submissions into the note, my lords. I want to give my learned friend.
Can you, all of you, give a collective note? Because there are too many notes.
My lords, if your lordship says final written submissions, we will compile it and give it to your lordship in one.
Every note of every council, somebody can take the lead and compile everything that has been put in right. If that can be done, it will be very useful.
What we'll do is we'll compile the note on our end, all our notes, and give it to your lordship as one note, just so that there's no trouble.
That's right. So somebody from the other side, state of Tamil Nadu, can take Bombay can take the lead, and the respondents' notes, even including like Nagamuthu and all the other learned counsel who have argued, just put a brief submission, so then
Your lordship, then like to do that.
all of it.
See,
all of
let these remain. So in whichever way you frame,
everything should be.
we need one.
Should this be part of that also, not that?
Yes, please, yes.
That's all.
Can I just,
We have only time.
I'll just take 10 minutes, my lord.
10 minutes.
Your lordships. My lords, the argument, my lords, that on legislative competence and colorable legislation has been placed. But one aspect, my lord, which was sought to be projected before your lordships was section 28A, which is an amendment, my lord, of the Tamil Nadu Act. So the effect of section 28A
Yes.
is saving in respect of Jallikattu. Well, 28A, the placement of the section is immediately after section 28, which is saving as respects manner of killing, prescribed by religion. Nothing contained in this act shall render it an offence to kill any animal in a manner required by the religion of any community. Why, my lord, 28 is referred to in the context of reading 28 is only because of the placement of the section, but 28A has nothing to do with 28 per se. 28A, saving in respect of Jallikattu. Nothing contained in this act shall apply to Jallikattu conducted to follow and promote tradition and culture, and such conduct of Jallikattu shall not be an offence under this act. Jallikattu is defined, my lord, under the act by the impugned legislation. Section 3 has been amended, Section 11 has been amended. Section 28A has been inserted, by which Jallikattu is taken out of the purview of the act. This is a case, my lord, where the state legislature has legislated, my lord, the conduct of Jallikattu out of the purview of the Prevention of Cruelty to Animals Act itself. Fact that it is done by way of an amendment, my lord, to a legislation which is traceable to entry 17 of list 3 may not be a complete answer, my lord, to it. That's why, my lord, the argument that colorable legislation is not merely where the concerned legislature, my lord, enacts in a law which is not covered by the list under which, my lord, it is competent to legislate, except that it is always, mostly it is used, my lord, in relation to a legislation that is brought out by a state legislature, because Parliament always has a residuary power, my lord, under 97. But point is this, my lord. Is this an amendment to the Prevention of Cruelty to Animals Act by completely taking Jallikattu out of the purview of the Act itself? You have legislated yourself out of the Act. And, my lord, where is a question of making rules if the rules are not, if the event takes it out of the purview of the Act, the enactment of the rules really does not improve the situation as such. Why colorable means, my lord, it is used in a slightly different way, which your lordships may appreciate. It's an argument, my lord, which is being raised before your lordships for the first time, not the pristine concept of colorable legislation. But this is an enactment of a law, my lord, which completely takes it out of the purview of a prevention of cruelty to animals, which is, my lord, the entry that is entry 17 contemplates.
Yeah.
This is not merely a regulation. This is enacting it completely out of the purview, my lord, of the legislative scope which is contained under entry 17. And rules, my lord, can never be elevated to the status of a plenary legislation.
Yeah.
Rules, my lord, cannot plug in the holes, my lord. Rules by itself cannot prop up a legislation, which otherwise, if your lordships find it adequate, if your lordships are accepting our submissions, your lordships will find the legislation as void and repugnant and invalid.
Yes.
Rules cannot prop it up.
Correct.
No, my lords, the one thing which your lordships had been brought to your lordships' notice, and my lord, with great respect, the that fell from your lordships is, to what power is subsection 3 of section 11 traced to? My lord, in my respectful submission, E, subclause E of subsection 3 of section 11,
Yes.
is, my lord, for an assertion of, or a legislative, my lord, recognition of the right of a citizen under Article 21. Meat is food. Slaughtering of animals for food has been recognized by this Honorable Court as possibly traceable to Article 21. Choice of food is part of, my lord, the right to privacy that has been upheld, my lord, in Puttasamy.
21 is not a source of legislative power.
21 may not be a source of legislative power, but every legislation which probably echoes, my lord, the exercise of a right of a fundamental right under Chapter 3 cannot be struck down on the ground of that it lacks legislative competence. But that is a reason why.
Then it's part of our culture and Article 29(1).
That's what I'm coming to, my lord. When it comes to, if your lordships recognize, lordships are pleased to accept that E would therefore echo a larger fundamental right that is available to a human being, a citizen, under Article 21. Then your lordships are left with A to D. Please look at each one of them. This is to maintain, my lord, this is to make the human beings safe.
And are you not belittling liberty in Article 21?
Liberty?
You have only talked about life.
Yes.
In Article 21.
Yes.
You connected it.
Yes.
Liberty.
Because that's a fundamental right.
Which incidentally, very ironically, this court has been always holding.
Yes.
Man's liberty is not to be treated as similar to the bare animal existence.
But this is not.
Now you'll have to reverse it and say animal liberty should be actually, elevated to man's.
No.
Liberty, same status.
My lord, if your lordships are looking at liberty of an animal or a liberty of a human being.
We're talking about liberty of the human being.
Liberty of a human being.
For a change.
Liberty of a human being, my lord, per se, it is also part of Article 21.
It is part, we are trying to connect it to culture. You see, when you're talking about my liberty.
No, culture, my lord, culture, your lordships will have to peg it under 29. Lordships will have to peg it under 29.
Now, why should we only peg it down only to that? Because it is all part, as you said, it's part of a connected whole.
No, my lord. Then don't legislate it out of the statute. Then don't legislate it, my lord, out of the statute.
No, but that is also part of legislative exercise.
No, my lord. I'm sorry, my lord. I'm sorry. If it is for the, if it is on a question of repugnance, your lordships may treat it as therefore part of the legislative power being exercised.
On that, in the context where
it's colorable on
certain other activities which also causes pain.
Correct.
And fear.
Yes.
They have been kept, actually have been excluded from the statute.
That's my lord. That's my respectful
Why
submission.
a third activity cannot also be
That's my respectful submission. Every activity under 11.3, which has been excluded because it says nothing in this section shall apply. Therefore, whatever is mentioned in section 11 is cruelty.
It is a presidential assent.
No, that, my lord, that is for the purpose of repugnancy alone. That is for the purpose of repugnancy alone. I'm saying, my lord, that there is a justification even in the Parent Act.
If there is no repugnancy, then concurrently state can make law.
There the argument, my lord, is of a different. There the argument was what I respectfully submitted before your lordships. You can't legislate it out of the statute. You can't legislate it out of the scope of entry 17. Then, my lord, it is not an exercise of the legislative power under entry 17 is my respectful submission.
Yes.
No, my lord, every aspect from A to D under subsection 3.
Essential.
Essential. Not only essential, it is for safeguarding the life of a man. Extermination of stray dogs because they are prone to.
Correct.
And every rule that has been framed, my lord, under the prevention of cruelty to animals is always, my lord, for the purpose of safeguarding the health, my lord, and health and welfare and well-being of a man. There, my lord, there is an echoing of a larger right that a human being is entitled to under Article 21 is my respectful submission.
Why should a human being have larger right?
No, that they do have, not under the Constitution.
Why should
I don't think anybody could argue, and nobody has argued
You're saying ecocentric. What is happening? You're putting with the woman issue.
I'm not.
No being is superior to another.
I am not saying any of these things, but I am putting it only under. I am putting it on a purely legal platform, which your lordships may kindly appreciate. My submission is, all right, my lord, Jallikattu, if it is therefore, my lord, an echoing of a culture and a tradition of a particular sect of people, para 53 and 54 of Nagaraj considers his arguments, holds it against.
Yes.
Corrections of Nagaraj, my lord, even if your lordships are pleased to examine the corrections of your lordships are sitting in a superior string.
Yeah.
What is a material that has been placed before your lordships to show that the conduct of Jallikattu in the manner, my lord, which is now contemplated, is part of an assertion of a fundamental right of a certain section of people traceable to Article 29. There must be some material. In my respectful submission, there's a total dearth of material. my lord, this is why I said that there was hardly a gap, my lord, of two weeks between the date of the review judgment and the promulgation of the ordinance. But that is not the attempt. The attempt is just to peg it on a non-existent, my lord, hook. My attempt is to see that it is part of the, my lord, that is because some persons perceive it, but that is not enough. There must be material, my lord, when the whole thing has been challenged before your lordships. For your lordships to conclude.
Muthu said, they taken to the temple, they worshipped. It is part of a.
No, my lord, somebody may view it as part of a religion.
That's right.
But that is not a religious practice. Somebody may view it, my lord, putting a vermilion on the bullock's head is not.
It says a section of the public. Section of persons can have a culture.
No, my lord, this is not pegged.
That is the beauty of India, the diversity of India.
No, my lord, this is not pegged under Article 25 also.
You should respect that.
Correct, my lord, but this is not pegged under Article 25. There is no assertion anywhere that conduct of Jallikattu is part of an essential religious practice of the Hindu religion. No. No, sir, let me complete it, sir.
25, not 25. Not 25, 29.
They apparently tried it in a review petition, but the review was rejected, that argument was over. No, my lord, just one more, my lord, and I leave it at that. Therefore, 53 and 54 of Nagaraj considers culture and heritage overrules that argument. And therefore, my lords, in my respectful submission, my lord, lordships being considered it from a purely legalistic point of view, this act, my lord, this impugned enactment, in my respectful submission, cannot be sustained under any one of the fundamental rights, including Article 29. And it is a colorable piece of legislation. So, the rest have been repeated to your lordship.
Thank you.
Grateful to your lordship.
Third judgment reserved. Parties are free to submit their collective compendium of arguments within a period of 1 week from today. Because it will take at least.
Mr. Giri, only one statement.
As you know.
Diwan has left immediately by saying nothing doing. I am not going to give any kind of indulgence as we requested him. Our request